a sudden you're being called a snitch. And then when you press for details, the person gets irritated with you because you keep asking them to explain what they're talking about. And they brush you off, and that you need to go somewhere. You would think that this is Nipsey Hussle making up this rumor about me. And if he said it the way Cowboy said he said it, on one of the times when he testified, he said it so many different ways. I haven't seen the paperwork, but I heard they have paperwork on it. All right, stop right there. If you haven't seen the paperwork, then why are you running your mouth about it, right? You're the one spreading this rumor in front of other people, in front of this stranger, in front of this lady. You don't even know that she's with me. Why are you spreading it if you haven't seen any paperwork, right? So you would think that he's putting a bounty on me. He's outing me as a snitch. This is Nipsey Hussle making it up. Cowboy didn't say anything. Rimpow didn't say anything. This was just Nipsey Hussle's doing. So this is a provocation. This would stir up a range of powerful emotions swirling around a reasonable person's head in the same or similar circumstances. Some of the emotions would be rage. You'd be enraged that he would do this to you in public, in the heart of Rolling 60s territory, in a complex that he owns in front of other people, when you just came to get some food. Confusion. You don't know what he's talking about. He's not giving you any details. Why is he doing this to me? Frustration. Refusing to give you any names, any details, so that you could get this supposed paperwork and clear your name. Humiliation. Doing this in front of Cowboy, Rimpow, some stranger, and Ms. Brianita. And fear for your life and safety. Nipsey Hussle carries a lot of weight. What if he calls you a snitch in a song and names you? These are the things that you would be considering as to why he's doing this in this public manner. Now, if he was just looking out for you and just trying to warn you about this rumor, why not walk you over to the side and say, hey, this is what I heard, you might want to go take care of it, you know, I'm just looking out for you, you better watch your back. No, he didn't do that. He did it in front of 4 other people. Now, the DA mentioned in his closing, well, why would Eric even care? He lives in Long Beach. Really? Where does he think Long Beach is? Does he think Rolling 60s can't get you in Long Beach? Does he think that you won't run into a Rolling 60s somewhere that heard that you were snitching when you're at the Hollywood Walk of Fame or the Santa Monica Pier? Do they think that you would only be in fear if you're in Rolling 60s neighborhood? I'm going to go through CalCrim Jury Instruction 8.44. It says, no specific emotion alone constitutes heat of passion. Neither fear, revenge, nor the emotion induced by the accompanying or following an intent to commit a felony, nor any of or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any and all of these emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. This was an act of impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately from choice, whether the choice is reasonable or unreasonable. So it's a range of emotions. It's not just, okay, were you angry? Okay, that's heat of passion. Were you in fear? Okay, that's heat of passion. No, it's all of the range of emotions, powerful emotions that would be stirred up in a reasonable person under the same or similar circumstances. So while under that heat of passion, from that provocation from Nipsey Hussle, this serious accusation done in this manner, a mere 9 minutes later, he shot and killed Nipsey Hussle. 9 minutes is a very short period of time for such a serious, life-threatening provocation and accusation like this. 9 minutes. Clearly, emotions did not have time to clear in that short amount of time. As soon as Mr. Holder got into the car, he told Brianita, drive around the block, which he did. He took out his gun. She parked in the alley after he told him to. He gets out of the car and he walks over and he shoots Nipsey Hussle. There was no cooling off period. There was no time to reflect. He was still acting under the heat of passion of that provocation. Look when he first approaches the group. He doesn't have any animosity in his heart. He's just coming over to say hello. It was because Nipsey Hussle made this accusation against him. That's what provoked him. Otherwise, he would have gotten his chili cheese fries and he would have went back along his way. This was the act that provoked him. This was a provocation and there was no cooling off period. The burden then is on the district attorney to show beyond a reasonable doubt that there was a cooling off period.
Yes, sir.
So let's look at the timeline of events. And this is from Defense Exhibit I, and we'll play that for you in a minute. At the 10-second mark, Eric Holder joins the group, shakes their hand, leans up against the car, and Nipsey Hussle starts talking to him about having paperwork on him. At 44 seconds, Brianita Nicholson joins the group. And she stays for about 53 seconds. At 4:20, Eric Holder leaves the group. At 7 minutes and 10 seconds, Eric Holder comes back and says goodbye. And at 13 minutes and 30 seconds, Mr. Holder returns and starts shooting. It's only 9 minutes and 10 seconds from the time Mr. Holder left the group after being accused of snitching to the time of shooting. Is that a cooling off period for such a serious public accusation by someone of the status of Nipsey Hussle? That's a very short amount of time to expect someone to cool off for this range of emotions. Let's talk a little bit about Cowboy, Mr. Herman Douglas's credibility problems in this case. Only 2 people testified that heard any of the conversation, right? Brianita Nicholson and Mr. Herman Douglas. According to Mr. Douglas, who's a registered sex offender for felony sexual assault and is currently on felony probation for car theft out of the airport court, mainly his credibility problem is that he blames himself. But at the same time, he doesn't want other people to blame him for not protecting Nipsey. So he's locked into this ridiculous narrative that there was no hint of any animosity, irritation involved in this conversation, that everything was just lovely, it's just homeboys chopping it up and everything was fine. Otherwise, he would have escorted Mr. Holder off the premises to protect the talent, as he put it. He even goes so far to say that retaliation for snitching is something that happened in the 80s and 90s, when both gang experts said that's not true, it still happens. And we know that all of the witnesses that I named earlier had problems testifying in this gang case. But even in his own Instagram video, he says, "Where I come from, snitches don't last." That's not in the 80s or 90s, that was June 2nd, 2022. He said, Nipsey never called Eric a snitch. We know that's not true. We know that's just wordplay. He didn't say the word snitch, but he said they have paperwork on you. That's just another way of saying the same thing. If someone says, "I never called you a pedophile, I just called you a child molester," it's the same thing, right? It's just another way of saying the same thing. He said he never even heard Eric use the term snitch, when we know from Brianita that he was constantly saying, "Are you saying I snitch? Did you say I snitch? Did someone say I snitch? Do you snitch? Have you ever snitched?" We know that he said it repeatedly. He described the conversation and the tone of the conversation as friendly. That's contrary to what Brianita told us. He held back a comment from Nipsey Hussle. The comment, "I wonder how this is going to unfold," which should have put him on warning that something was up, that Nipsey had a concern when he saw Eric Holder drive up. He never mentioned that in his May 2019 grand jury testimony that Nipsey made this comment. And he never mentioned it on direct examination when Mr. McKinney asked him, "What did Mr. Nipsey Hussle say when he drove up?" And he didn't admit it on cross-examination until I found the clip on YouTube from his June 2022 interview that I just played for you. And in that interview, he said that this haunts him. So we know that this is something that he wouldn't have forgot to tell us. If this was something that was haunting him ever since it happened, all the way in 2022, now that's haunting him that Nipsey said that, then why didn't he tell us that at the grand jury? Why didn't he tell Mr. McKinney that Nipsey Hussle said that? Why didn't he tell us, this jury here, when he testified on direct examination, that Nipsey Hussle said that? Because it runs counter to his narrative that he had no idea that something was about to happen. Not to mention, he's got a financial interest in this, in continuing to do several YouTube interviews, paid and unpaid. Let me talk to you about the law in this case. The standard for a criminal case is beyond a reasonable doubt. It's the highest standard we have. That's the burden of proof that the prosecutor has to prove beyond a reasonable doubt. So when they charge first degree, willful, premeditated murder, they have to prove that beyond a reasonable doubt. What does that mean? That means you have to have an abiding conviction of the truth of what you're voting on. And you have to be able to live with it. So not just today, not just tomorrow, but 10 years from now. You have to be able to look back 30 years, 50 years and say, you know what, I made the right decision. Deliberate and premeditated murder is given in the instruction 820. And this is how it describes deliberate. The word deliberate, which relates to how a person thinks, means formed or arrived at or determined upon a result of careful thought and weighing considerations for and against the proposed action. Soon, when we both sit down, you're going to get your final jury instructions and you're going to go into the room and you're going to deliberate. You're going to give careful thought and you're going to weigh the considerations for and against your verdict. it also says, if you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not under sudden heat of passion or other condition precluding the idea of deliberation, it is murder in the first degree. So it has to be not under the sudden heat of passion. So that takes away the element of malice of forethought, and that is what makes the homicide a voluntary manslaughter instead of a murder. So let me read that again. Must have been formed upon pre-existing reflection and not under sudden heat of passion or other condition precluding the idea of deliberation. This is what happened in this case, and this is what happened, and I told you this is what happened from the beginning of the case. I was up front about what we were going to show the evidence showed. That Mr. Holder had no idea he was going to be there that day, that he was provoked by this provocative accusation that he was a snitch, and that he acted under the heat of passion based on that provocation. Within 9 minutes of him leaving the group, he returned and started shooting. That is not a cooling off period. Now, counsel gave you some examples of what a heat of passion would be, that it has to be immediate, that you have to act rashly, like immediately after being provoked. That's not the law. The law doesn't say that it has to be a situation where you come home and your child is being molested in the bedroom and then you immediately react. No, the law doesn't say that. That is one example of heat of passion, but the law doesn't put that time limit that it has to be immediate. This is what CalCrim 8.42 says about sudden quarrel or heat of passion and provocation. The heat of passion which will reduce a homicide to manslaughter must be such as a passion as naturally would be aroused in the mind of an ordinary, reasonable person in the same circumstances. Now, this is important because I want you to understand what heat of passion is and what the law says heat of passion is. Heat of passion does not require the provocation to provoke you to kill. That's not the law, and I'll read it to you in a minute. So you might say, yeah, you know, this was pretty bad. This was really serious. It would arouse emotions in me, but I wouldn't go and kill a person because of that. That's not what's required. The law doesn't require that the provocation be severe enough to drive a reasonable person to kill. Rather, the issue is whether the actual provocation was such that a reasonable person would commit any act rashly and from passion rather than from judgment because of it. So if you tell yourself that's pretty bad, I probably would sock him in the face, that's provocation. That's an adequate provocation. That would cause you to react rashly without thinking. Doesn't mean that it would cause you to go get your gun and shoot the person. That's not what the law requires. Just that you would act rashly under that provocation and without deliberating. So how long would it take you to calm down from this public accusation of being a snitch by someone as famous as Nipsey Hussle? 9 minutes? You think in 9 minutes that you would be cooled off enough to deliberate and premeditate? No. No, 9 minutes is way too short for something this serious, with the consequences being this serious. So what is heat of passion? What is heat of passion? Heat of passion negates malice of forethought for murder and makes the homicide voluntary manslaughter. So there's manslaughter, there's homicides, and homicide is one human being killing another. There's voluntary manslaughter, and there's murder, different types of homicides. This is not some liberal California rule that we have here to protect defendants. This is a common law rule that came down to us from England. This is not a defense. The accused, if they're convicted, they don't get to just walk. I'm sorry, if you find that it was heat of passion, that's not a defense. You're not going to find not guilty. You would find guilty of the correct level of homicide. It's not victim blaming for provoking you. We are all presumed not to kill when provoked. That's why it's a crime. That's why it's voluntary manslaughter. It's not an excuse, and it's not a justification. What is it? It's simply determining the correct level of homicide. As I said, there's voluntary manslaughter, then there's murder in the second and the first degree. What you are doing, and what we're asking you to do based on the evidence in this case, is find that the correct degree is voluntary manslaughter homicide because of the provocation, because he was acting under the heat of passion. Coming to the end. This case has been overcharged from the beginning. Mr. Holder was always ready to take responsibility for his actions.
Ladies and gentlemen, base your decision on the facts as presented in this court. Continue, sir.
Thank you, Ron. I told you up front that Mr. Holder Jr. shot Nipsey Hussle and accidentally shot the other two individuals in this case, but that it was voluntary manslaughter. But it was overcharged as a first-degree murder. Not only that, Kerry Latham and Shermy Villanueva, he was also charged with first-degree attempted murder of these two individuals. That tells you that it's overcharged. Plus, they added an assault with a firearm against those two individuals. So what they're really telling you is, okay, if you don't go for the attempted murder against them, get them for the assault with a firearm. These other two charges would be a fallback position. There was no specific intent by Mr. Holder Jr. to kill either one of these two men. I've heard counsel tell you a couple of times that attempt is just an ineffectual act towards killing. No, it's not just that. It's also, you have to have the specific intent to kill that person, and then you make an ineffectual act to kill that person. That's what attempted murder is. And if it's premeditated, deliberate, then they also have to prove those allegations too to get first-degree attempted murder against these two individuals. There's no evidence that he had the specific intent to kill Kerry Latham. There's no evidence that he had a specific intent to kill Shermy Villanueva. He didn't even know these two individuals. They weren't even there when he had the conversation with Nipsey Hussle. We saw who was there. It was Rimpau, Cowboy, Ms. Nicholson and the stranger. And when he walked away, it was those same people, except Ms. Nicholson had already left. So Mr. Latham and Mr. Villanueva was not even part of this conversation about snitching. So, and you're going to see in the video that they arrive as Mr. Holder is walking away. So he had no reason to kill these two other individuals. He didn't even know that they would be standing there at the time when he came back. Nothing was ever said to Mr. Latham, and if you remember, Mr. Latham testified that when Mr. Holder said, "You're through," he said he wasn't talking to me. And Mr. Villanueva never heard any words. He was too far away from Mr. Holder. I'm able to play. Where are we? Okay. Could you back up a little bit to the 4-minute mark? Let's try from there. On the right is the SUV driven by Mr. Villanueva. You see Mr. Latham gets out of the car, Eric shakes Cowboy's hand, he doesn't shake Nipsey Hussle's hand, and he walks away as Mr. Latham comes over to the group. Mr. Villanueva is still in his SUV, and then you're going to see him park. So Mr. Holder had no contact with Mr. Latham. He was walking away as Mr. Latham was arriving. So why would he have an intent, a specific intent to try to kill Mr. Latham? Makes no sense. It's overcharged. It's an assault with a firearm. Or at least an attempted voluntary manslaughter. But it's definitely not attempted murder, let alone attempted first-degree premeditated, deliberate murder against Mr. Latham. Where's the deliberation? Could you play it a little more, Mr. Clayton? Are you at 440?
Yes.
Okay. Let's play it a little more until we see Mr. Villanueva get out. There's Mr. Holder walking across to Ms. Nicholson's car to get some extra money to finish paying for his meal. Mr. Villanueva testified that he was doing something with his dashboard, I think, that was malfunctioning, so he didn't get out immediately when his uncle got out. Okay, now Mr. Villanueva is on the scene. Mr. Holder has left. He came back, said his goodbyes, and we know what happens after that. He returns. Let's go to 1258, Mr. Clinton. In the top left corner, this is the video that you've seen many times over, but I want you to note the position of especially Mr. Villanueva at the time of the shooting. He is not in between the cars. He's maybe about 5 feet away. Thank you, Mr. Clayton. There are a number of ways where Mr. Latham could have been struck and Mr. Villanueva grazed. That raised reasonable doubt as to the specific intent that Mr. Holder supposedly had to murder these two individuals, let alone premeditated. The coroner testified that when people are close together, Nipsey Hussle had through and through wounds. You notice Mr. Astrodome was standing right in front of Eric Holder when he started shooting. Before Mr. Villanueva was able to turn and run, we know that there were through and through wounds that went through Mr. Villanueva and could have grazed, through and through wounds that went through Mr. Astrodome and could have grazed Mr. Villanueva. So it's not even clear that Mr. Holder shot directly at Mr. Villanueva. Why would he? He was there to take care of business he had with Mr. Astrodome. Why would he shoot on the side of him when his target is right in front of him? Why is he going to shoot to hit Mr. Villanueva, who had nothing to do with anything, let alone intend to kill him and premeditate on him? Same thing with Mr. Latham. Mr. Latham was closer to Mr. Astrodome, but he had no reason to intend to kill Mr. Latham. He had no contact with him. The men didn't know each other. They didn't know each other. Mr. Latham even told you that he wasn't talking to me when he said you're through. He was addressing Mr. Astrodome. The coroner also testified that there could be ricochets, so that when Mr. Latham turned to run, a bullet could have ricocheted off of one of the cars or a door handle and lodged in his back once he turned. When people are close together like that, bullets can ricochet off of things and strike other individuals. That's what the coroner testified to. We know that shooting with your offhand, whether your offhand is your right hand or your left hand, shooting with your offhand, you're not going to be very accurate, right? Anyone that's tried to shoot a foul shot with their left hand knows what I'm talking about. Try to write with your left hand, or try to do something that requires dexterity with your offhand. It's not going to be accurate, it's not going to be as strong. And in this case, Mr. Holder was shooting two guns and not able to use the proper one-handed grip. And so therefore his accuracy was reduced. That's also a reasonable inference from the evidence. And when Mr. Latham is down on the ground and incapacitated, if Mr. Holder had the specific intent to murder him, he could have finished him off right there, right? But he didn't do anything to him. He just dealt with Mr. Astrodome and kicked him in the head on his way up, on his way out for good measure. That shows rage, right? That shows a heat of passion. Counsel is calling it something personal, but that's heat of passion. That's what you look for, the conduct of the individual. So the 2 attempted murder charges are overcharged. They should be assault with a deadly weapon. I'm going to read you a jury instruction about 2 reasonable interpretations of the evidence. And it's CalCrim 2.01.
CalJIT.
Yes, CalJIT, we're using CalJIT 2.01, and it's entitled Sufficiency of Circumstantial Evidence Generally. I'm going to read this whole paragraph so I'm not accused of taking it out of context. But this is circumstantial evidence. And when there are 2 reasonable interpretations of the evidence, and one points to innocence and one points to guilt, you must accept the one that points to innocence. So if you think that Mr. Lathan and Mr. Villanueva were struck accidentally because he was shooting with his offhand, if you thought that it's reasonable, as the coroner testified, that it could have been a through and through that struck, especially Mr. Villanueva, because he was standing behind him. If you think that Mr. Lathan could have been hit by a ricochet, if these are reasonable interpretations of the evidence, then you must accept that, and you must reject the one that points to guilt. So it says, also, if the circumstantial evidence as to any particular count permits 2 reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt the interpretation that points to the defendant's innocence and reject the interpretation that points to his guilt. You must, not you can, you should, you can if you want to, you must accept the one that points to innocence if they're both reasonable. So what I wanted to do is show you all of the facts and circumstances surrounding why Mr. Holder shot Mr. Askedom and how Mr. Latham and Mr. Villanueva got grazed accidentally. I wanted to show you that he was just enjoying his life. It wasn't some jealousy or any of the other rumors that might be going around. He was just living his life in Long Beach and just happened to come to that center. No one knew Nipsey Hussle was going to be there that day. There's no evidence of any personal animus or any jealousy on behalf of Mr. Holder. That's all speculation that the district attorney is coming up with because he said you're through. You're through spreading rumors about me. You're through talking smack about me. You're through humiliating me, embarrassing me. You're through putting a bounty on my life. That's what we're dealing with. Because you see, when he first walks over there, he's perfectly friendly. He doesn't have anything against Mr. Askedom. It's Mr. Askedom who then starts going in about this snitching stuff. What is that about? That was a provocation. That was a heat of passion. So I wanted you to see all of the circumstances that led up to March 31st, to see that Mr. Holder had no animus and that it was this provocation by Mr. Askedom that caused my client to become so enraged that he acted rashly without reflecting, without a cooling off period, and that this was voluntary manslaughter in the heat of passion. Thank you.
Thank you. Mr. McKinney?
Yes. Let me say at the outset that what you hear during argument is not evidence. And oftentimes, attorneys will say things in their argument that was never introduced into evidence. And you should not allow those things to rattle in your head as if they actually came out in court in the witness stand. Your decision is based on evidence, not counsel's version of a trial that you didn't hear. So keep that in mind. Now let's talk about little Eric Holder, as counsel called him. This sweet, innocent kid who gave up gangbanging for a life down in Long Beach. He came to LA that day just because he wanted some French fries. He just wanted to hang out. So he came to this place that he was familiar with, right? Long left the gang behind. He's a working man now and a father. This is the version that Mr. Jansen tried to paint for you. But what you saw was Eric Holder show up in this neighborhood shirtless, flossing his Rolling 60s tattoos in the heart of Rolling 60s territory. That's not somebody who thinks he's giving up life in the gang. What you know is he showed up in this neighborhood not with one, but 2 loaded handguns. Does that sound like somebody who left the gang life behind? And even when he was living in Long Beach, he was always known to have a gun, according to Brian Needham. There's a certain inherent contradiction in the defense's presentation. On the one hand, they want you to believe that Mr. Holder, who we know has been out of this neighborhood for some period of time, long period of time. And they want you to believe he's out of this neighborhood and he gave up gang life. He's no longer into all that stuff. A lot of it is stupid anyway. We know this. This whole snitching thing is just stupid. They tell on each other all the time anyway. But he's left that behind. On the one hand. On the other hand, he wants you to believe that a 4-minute conversation with one of his friends from the neighborhood, where his friend gives him advice that people are talking about him, threw him into a rage, where he lost all considered judgment. And even after 10 minutes, he couldn't get his head straight. Even after leaving the location, he couldn't get his head straight. There's a major contradiction in that, because if he had really left the neighborhood and left gangbanging behind, he wouldn't care that somebody in the neighborhood in which he doesn't even live might be talking about him. I mean, even the guys who live in that neighborhood don't care that there's somebody in the neighborhood that might be talking about them.
Objection, arguing facts, not in evidence.
Ladies and gentlemen, we told you, we'll tell you again. Make your decision based upon the evidence received in this courtroom and nowhere else. You may continue.
How do we know it's